Okay, well, welcome everybody. Looks like we've got some good attendance here, approaching 100 already. So we're glad that you can be here for our 2025 LAC legislative forecast webinar that we have to talk about some of the bills that are currently before the legislature and some of the changes that we're working on and some of the highlights that we think are positive, some of the concerns that we have. And so appreciate each of the LAC members who are on to present today, and also the other members of LAC for all the work that they're doing more behind the scenes to help with this pending legislation. So we are going to start. Ryan Bonham. And sorry, we made some changes in the order just minutes ago. So we're going to have to just kind of reorganize some of these slides. But Ryan Bonham is going to start with Senate Bill 201, sponsored by Wayne Harper. This is a bill that we've been working on with him for some of the provisions. He has included some other things that we weren't aware of until last week. But Ryan, I'll go ahead and turn the time over to you.
Great.
And I'll pick it up after.
Perfect. So Senate Bill 201 addresses really these 5 topics, and we'll go through each of them individually. First is water-wise landscaping, some small adjustments to water-wise. Second is a limit to rulemaking and lease term limits under rules. Third is a rental fee adjustments based on the new rental fee that was allowed 2 years ago. Fourth is an allowance for an HOA representative when you're selling common area. Kind of a cleanup little portion there that makes it a little bit more effective and cleans up a lien issue. And then the last one is a defective construction lawsuit limits that was added into our bill that we'll talk about. First, water-wise landscaping. So this is a pretty simple one. We at one point the law had where it was kind of mistyped out where the HOA had to implement water-wise rules on common areas, and we clarified to where there's no landscaping. The only water-wise requirement is for homeowner maintained areas, not for, and I'm going to ask Tyler and Quinn if I misspeak to step in and correct me here as well, because they've been neck deep into all of this. And so just as my double check, don't hesitate to speak over the top of me if I say something wrong. But water-wise, really the idea here is that the only water-wise requirements for water-wise policies is on homeowner maintained areas. And just a clarification that the park strips, converting a park strip in a homeowner maintained area is less than 8 feet wide, right? Where the HOA cannot limit their work and the homeowners work on those 8 feet wide or less park strips. Kind of helping with that definition of what a park strip is. Pretty easy cleanup on the water-wise that was implemented a handful of years ago. Next is a rental restriction. A little bit of history is that the statutes allowed for rules to be able to limit the lease terms. And this was a concession based on the rental fee where the rental group wanted to limit the rules, the duration of rules. In the current draft, it still says 6 months, but it's changing to 90 days. What this means is that in the rules, so not the CC&Rs, but in the rules of an association where the board approves it, you can limit leases to be more than 90 days. Let me say that again. So a rule passed by a board can require, when you have a rental limitation, can require the rental agreements to be 90 days or more. This basically is limiting the nightly rentals and monthly rentals. Is that clear enough? What do you think, Tyler, Quinn?
Yeah, I think that's great. So previously the statute just said you could set a minimum lease term by rule, but it left some room for some gamesmanship. In theory, an HOA could say the minimum lease term is 10 years or whatever, right? And that would operate as a rental cap on all kinds of rentals. But what the target of this initially is to address very short-term rentals. And so it's likely to land at a 90-day cap if you're setting it by rule. If you want to do something more aggressive than that, you'd have to go to your covenants to do it. Good
Perfect.
summary.
Yep, thanks, Tyler.
Ryan, you pointed out that it currently says 6 months or less, likely going, changing to 90 days. And then just so everybody knows, the other stakeholders on this besides our group have already indicated that they want to revisit this next year and maybe tweaking it even more. So even though we've got that, we can anticipate discussions and likely another change in a year. So
Yeah, and I think now's probably a good time to know that we're in the middle of the legislative session. Things are rapid fire change right now. In fact, we were hoping that this bill was going to be updated with some changes overnight to reflect some of those, but specifically the 90 days in this slide. But there's a couple other changes that we'll talk about because things are moving and changing fairly quickly right now as these get pushed. So these aren't anywhere, they're close, but not final. That's probably the best way to say it. And these look like they're going to pass, both the water-wise and this rental restriction, and as well as the next one, which is rental fees. All are moving forward with this bill, and this bill is looking likely to pass. A little bit of history and background on this. Years ago, the rental group passed an HOA law that said we couldn't treat rentals any differently than a normal homeowner, meaning we couldn't charge any extra fees. 2 years ago, we were able to say, look, there's extra work that's done for these rental units, and passed a law that allowed $200 annually, is what it has said, per rental unit for those extra work, extra labor that rental units, cost. And it can't be paid out to the HOA. It needs to be paid as administrative costs, right? The operations cost. That's a little bit of the background. Now, on top of that, Senator Harper, that's been great to run some of the bills for us. He has got a lot of pushback after this bill passed, allowing the $200 from the different rental and apartment complex lobbyist groups, and so he had some clarification that wanted to kind of help tighten that down to make sure that it's truly being approved by the board. And that the homeowners are aware of it. And so that's the nuts and bolts of what we're talking about. I'll go into some of the details, but as a gist, these other 5 points. Number one, it's got to be in the rules. And there's some clear definition about it being in the rules where the board members need to vote. You can only do it once every 12 months instead of annually. That's being updated. So if you do it in October, you can't do it again in January, right? It needs to be once every 12 months for the $200 charge. The notice, again, the draft right now says 30 days, but it's going down to 15 days. So you have to send a notice to the homeowner that you're going to hold a meeting to change the rules, which is currently in the Association Act, but not in the Condominium Act. Now, know that this requirement will be in the Condominium Act as well. And so if you're applying this rental fee, that you'll need to have this specific notice separate from your normal notice for changes to rules in the Association Act. And that's it. The notice would be pretty similar, except that the notice needs to contain a couple of two specific things in it. And that's kind of my next slide. The same items need to be sent 30 days out after the meeting and the approved rule change. You have 30 days to send out these specific requirements as well. And then the final part is that the lot owner can contest the fee. Here are the requirements of notice. So it says an association shall provide each lot owner impacted by the fee a notice describing, one, the new administrative expense that the association intends to cover using the funds from the fee. And know that we've been pushing a little bit on that term new, and hopefully get that changed, but it hasn't been impacted because new could be problematic on what's defined as a new administrative expense. And then the second item is the circumstances that require the association to impose or increase the fee. So those two things are required in both the notice 15 days before and in the notice sent after the rule is passed. Those are significant adjustments. It does require, as is any board approval, that a majority of the board needs to approve the changes. That's already required in the rule amendment statutes. Here's the last part on contesting the fee. As drafted, it says a lot owner may contest a fee described in 9C, but providing the association a written request that the association will waive the fee if the association fails to provide the notice described, which we just went over, within 30 days after the day on which the association imposes the fee, or 2, the notice the association provides the lot owner does not contain the information required in subsection 12. And if a lot owner contests a fee by submitting a written request, an association shall waive the fee if we didn't provide the notice or it does not contain the information. So pretty critical additions where we have to provide the 15-day prior to discussing in a board meeting, right, to amend the general rules. And then within 30 days, we have to send out that final notice. Tyler and Quinn, is that 30 days after being changed as well?
Yeah, so anytime if you're changing the fee amount, you're saying?
Yeah, I wanted to make sure that the 15-day before the meeting notice, I know we were adjusting that. It was at 30 and we adjusted it down to 15.
15,
But
yeah.
the 30 days after is not being adjusted to 15, correct?
I don't believe it is. I think it's staying at 30.
It's just the 15 days before.
Yeah,
Correct.
and we still have some work to do with Representative Harper, because even the what we want 15 days before in the substitute bill, it is still 30 days. So so
we're assuming that'll be easy to go down to 15.
Well, and he has represented to us in phone calls that he's willing to adjust it down to 15, which is nice. But we just sometimes there's a disconnect between the lawmaker we're working with and the Office of Legislative Drafting, and it can be a real challenge because it can result in ambiguities and hiccups. So that's a big part of what we've been doing is keeping legislative drafting on track with what we've agreed to.
Yeah, and I've been pushing to remove this term new, because I think that's a little ambiguous on what is a new administrative expense and could pose some issues within the requirements there. Anything else that I missed on the rental fee?
Great summary.
Yep.
I think the intent is because, as we know, a lot of management companies rolled out this fee and there was kind of a backlash by owners and they reached out to lawmakers. And I'm grateful that Senator Harper didn't completely abandon this, because I know he's taken a lot of heat for this. And instead, he's tried to balance it. I know it's a burden to put out additional notice and adopt it this way, but this is his effort and it's his personal agenda to try to balance the fee versus owners that have complained about having to pay the fee.
Yeah, it's great to have a representative that will carry our bills for us, right, and help us to do that. That's a significant thing, and Senator Harper's been great. Okay, next item is the sale of common area. This happens rarely, but when the association has some common area, we had a community, for instance, that had a pool that had been defunct for a long time, and we sold the pool and renovated and sold it to a third party. This is an effort to clean up when a homeowner purchases the land or has lien rights within that land, that truly the association can have somebody represent the rights there, and it cleans that up. Tyler had some personal experience there, and maybe you could speak to the efficacy of this and why it's so needed. It's a little bit small. It may seem small, seemed a little bit small to me and meticulous, but that's why we have attorneys that deal with that stuff.
Yeah, I can talk on that. I mean, this is something we worked with them on last year to resolve some of it. Again, the legislative drafting, in doing it, they didn't completely include our suggestions. So unfortunately, it resulted in some ambiguity. That is one of the issues we're trying to fix this year. So, and again, that's not in the substitute, so we're still working on them to get that done.
Great. Final item within this bill is construction lawsuit limits. And so while there were already some limits, this amendment limits those that can bring a claim against a developer, right? We're talking about construction defect lawsuits, not other types of lawsuits, but specific to construction defect. And it limits those that can bring a claim to those that's had an original contract, right? Had an agreement. And so, they had to have an agreement there. And then it outlines specific steps required to bring a claim. Certain notices, right? You have to send a notice with a description and request that they repair those things, whatever's in defect. And then they have 9 months. Of significance, at first glance, this looks like it's all just defending builders. But it does actually obligate builders to act, and without having to go through a lawsuit, it may help on that end. So as with most good laws, there are two edges to each sword, right? And this does require the developer to act in those repairs, and can be a benefit there. Anything else that we worked on this?
I think you were right to point out, Ryan, that we didn't ask for this particular section, and this was according to Senator Harper, driven by an insurance commissioner that's looking to address a housing affordability through creating more affordable insurance policies for builders of condos. So it's going to be hard to contest this one as well. Anything related to housing affordability is a challenge, but we would encourage all that are in attendance to take a look at that and provide concerns if you have it, because this is not something that we drafted and prepared. So if people have concerns, we welcome that feedback.
Perfect. That's the last of mine. Quinn, I believe you're next. Is that right?
Yeah.
You're back up at the top.
Yeah, move up there for a second. So
Quinn, before you start, can you try to maybe adjust the slide? People can't see them. We're seeing the next slide and notes, making the slide really small.
We see the presentation view.
Great. I'll fix that. Give me 1 second.
Thank you.
There's just a few questions in the Q&A. Did we want to answer those now or later?
Yes.
Let's go for it.
So,
Okay, can notice be given through our e-newsletters for both the 15 days and the 30-day. You would just have to follow the notice provisions under your governing documents or the Nonprofit Act if that applies to satisfy that. I don't believe it dictates a specific method of notice as currently drafted. Okay, and then Amy wanted clarification on what the fee is for. So the fee is imposed by an association on any unit that is a rental for the extra administrative burdens related to that rental. So if you have extra administrative burdens in tracking tenant information, tenant contact information, notifying tenants, contacting owners with special circumstances or information that apply to them being a landlord, then you get to charge up to $200 per year that offsets those administrative costs of overseeing and managing the rental aspect of it.
So,
Okay.
and then in the chat, there's a few more talking about, are we required to allow leases of 90 days?
So I sent a response back to this from Natasha.
Yeah.
Yeah, so we're not required to allow rentals of 90 days or more if you have a valid rental restriction in your CC&Rs. Now, again, this is all a forecast, and I think that's a good disclaimer. We don't know where the law is going to settle on all these things, but what you'll want to do is check the final draft, and we'll do an update to this group and everyone at CAI. And if your minimum lease term exceeds whatever passes, you'll want to update that in your rules and revisit it for your particular association.
And then to Amy Alexander, yes, the rental fee is in the rules, not bylaws, CC&Rs. Doesn't need to be amended in.
Okay. All right, moving on to the next one, Ryan. Yeah, if you can move that down. So I'm addressing House Bill 262. It's regarding the board education requirements. You can go to the next one, Ryan. So this is, the sponsor is Cheryl Acton. This is a bill that we've been working on with her on and off for about the last year. Bruce Cutler of our Legislative Action Committee, he's really been in contact with Representative Acton. And this is also a movement that National CAI has been working on, is some type of board education to ensure that boards are familiar with what their duties are and how they can best run the association. So it does, if it passes, it establishes some new sections in both the Condominium Ownership Act and the Community Association Act. So next slide there. Right, and so the key provisions that we have are defining what the requirements are for the board members, talking about the topics that have to be covered, and then also how they report, how it's maintained by the association, and steps that can happen or that would be taken if a board member is not compliant with these board member educations. So, and then also again, has the oversight by the Department of Commerce. So go ahead and click through that onto the next one, Ryan, where it talks about the education requirements. So it does include certain topics. And so this is a summary of the list of topics that we have. Again, the purpose is really to help the board members understand more of what their responsibility is on various topics, right? Not just understanding the governing documents, but also the statutes that interplay with your governing documents, principles on ethics and leadership, what duties you have as board members, the association finances, what the maintenance responsibilities are, and how a reserve study plays in with that, so that you're planning for the future, minimizing risk and having insurance, and then also just really addressing conflicts and how those can be resolved. So it's really good. It's not overly bearing is the hope, and that is that it's just 1 hour of education per year, really 90 days as soon as they get on the board. So you've got a little bit of grace period. And so people who are serving on the board year after year after year, definitely getting different topics. Hopefully they're learning more besides just the 1 hour a year, but again, helping those board members understand a level of what their responsibilities are. Next one, Ryan. So the compliance, how do you know if somebody's done that? So once the board members complete their education, they have a certificate or some document showing that it's been completed. They keep it for themselves. They also give it to the secretary or the manager to include that as part of the record of the association. And so those records can be requested by homeowners. And so they should be maintained for 3 years. That may change to 4 just because of another issue that we'll touch on down below when it comes to a remedy that homeowners can seek. So a couple of important issues: if a board member is serving on multiple boards of HOAs, they only have to do the education once, not per board. They do it one time, and the certificate that they get, they can share with the multiple associations. There's one more on that slide, Ryan, and I see that there. Okay, there's a question. I'll address that later on about the types or how they do the education. So another important thing is when it's under declarant control or the developer is still in control, this education requirement does not apply. So next one, Ryan, gets into what do you do if a board member is not obtaining the required education. So this is similar to what we see in other provisions of the statute, where a homeowner can send a demand and basically state, you didn't give me the record, or you're not in compliance. So you have a time period, 90 days to come into compliance. And kind of the consequence of being out of compliance is you don't just do 1 hour, you do 2 hours of training. And if a board member is still refusing to do that, they face potential removal by the other board members or even a court order if the homeowner brings a lawsuit. And it does grant the homeowner a claim, a right to bring a lawsuit if that noncompliance is not remedied within the time period. And if the board does not remove that non-compliant board member, and then it allows them to recover $250 and then also their attorney's fees. So it does this 3 years to bring the action. That's the time period that they have, and that is where, again, in that prior slide where it talked about the association keeps the documentation for 3 years. We're looking to change that to 4, just because you don't want to destroy a record and then somebody is asking for it and you don't have it anymore. So,
Quinn, real quick,
yeah,
on the 90-day period to remedy non-compliance, and then the required 2 hours. So if they get cited for not being compliant, is it 2 hours in that 90 days then?
yeah, they would have to do
2 hours after
within
that.
Nope, 2 hours within that 90 days to cure the non-compliance.
Great.
Okay. Yeah, next one. Okay, so enforcement and oversight. Again, this gets to what does the board do as part of this, and making sure that all board members are getting trained. And so you do have to check. I mean, that's where the board members are kind of you have the checks and balances where they're making sure not only themselves but the others are taking the training, that they're getting that compliance document or certificate. And so it's being maintained as part of a record of the association. When an owner requests that it's provided to them. And then if a board member is out of compliance, then the board can take action of removing them if they're refusing to get the education to come into compliance. So the oversight of this is done by the Department of Commerce. It will keep a list of the approved education providers. We're still working with them on that. It may not be in the statute of who that is, but we would work with them on who is approved to teach the course. And we've got to decide how those standards are set, how you get on the list, how you remain on the list by complying. There is a question that's talking about, will our chapter or will the state be providing online resources for this education? It does talk about that in the bill, and that is another one of those issues that we would be discussing with the Department of Commerce, of different methods for board members to receive the education, ensuring that the education that's there is satisfying the standards. And then the other issue that really needs to be addressed is this would implement an additional government section or add a burden, which does increase the cost. And so it's how do they address that fiscal note? And so that's still being discussed of how that financing will take place. It may be that they pay a fee as they receive it, or as HOAs update their HOA registry with the different board members, the fee to do that may incrementally increase a little bit to cover that cost. So go to the next one, the key takeaways. And so again, key takeaway is board members are required to to take some training. There is an issue there in the chat about is this a concern where requiring them to get an education adds another hurdle of getting people to serve on the board because it's already difficult enough. Yes, that can be an issue as we've looked at it and weighed the pros and cons, that it is beneficial to have board members who are willing to get educated. So if you have people that are saying, I'll serve on the board, but I don't want to learn about what my duties are, they may not be a great person to be on the board. And so it is difficult to get people to serve, and it may incrementally increase that difficulty, but overall, we think that it should result in better board members, and that is an issue we can address. So I'll let everybody read the slide because I know we've got to move on to the next. Are there other questions? No, I think we've addressed those. So we will go ahead and move on to the next one with Scott.
All right, I got a pretty easy one compared to everybody else. This bill kind of came out of nowhere. Solar panel restrictions changing it. House Bill 119. What this bill does is it cleans up the solar language to make the bill easier to read. It reorders some of the provisions. Clarifies that any solar prohibitions must be in the declaration. That was already there, but it makes it clearer with the language cleanup. And then clarifies that restrictions, any placement restrictions can be in the rules as long as we're not infringing on the 5% threshold that's already established in the statute. The biggest concern that LAC has with this bill is it requires any association that wants to prohibit solar panels to get 67% of the voting interest of your association to amend that provision or add that provision to your declaration. This bill actually calls for a greater than 67%, but there's other areas in the code that cap that at 67%. So kind of what we saw last year with the waterwise, where there's conflict in the bills, we don't really know where this is going to kind of play out. But 67%, I think, is we're confident in that. And then for this one, obviously the intention of this bill is to make it easier to allow solar panels in community associations that are prohibiting them. So if at a future point you want to add solar panels, the lowers the voting requirement regardless of what amendment clauses are in your declaration to a requirement of greater than 51% of the voting interest. So we have a little bit of concern there. If you go to the next slide, Ryan, you can actually see the language here. As you can see in 56, greater than 67%, and then in 60, greater than 51% for each of those, the prohibition and the allowing. So again, like our concern, if you go to the next slide, Ryan, LAC's concerns are basically codifying different thresholds for one-off issues that don't align with the association documents is a concern, and where people can make mistakes where they're either trying to prohibit or allow solar panels in their respective associations. Just makes it harder, similar to what we're trying to do with the rental fee notice, of make that align with the already established rulemaking procedures, just to make it easier for management companies, boards, and self-managed associations to be able to navigate the nuance of this law. But pretty straightforward bill, not a lot to it. So.
Good afternoon, everybody. Ryan, if you could switch the next slide. I get the opportunity to talk to you about a couple of bills presented by Representative Jordan Tusher from South Jordan. The first one is HB 327, and it makes a few changes that we'll discuss. First is for either condos or PUDs, any ARC disapproval or rejection of plans needs to be done in writing, and it needs to cite, currently it says the rule that prohibits or that the plans would violate. I know that we've suggested that rule be changed to governing document provision because that's probably more likely to be in the CC&Rs than the rules, but we'll see how that goes. If you'll go to the next slide, please. There's also a proposed limitation on rules for both condos and HOAs. Rules would not be allowed to be used for restricting parking on public streets, keeping an item in your home that you're otherwise legally allowed to have, having a basketball standard on your driveway or your property, parking in a driveway that the owner has a legal right to park in, which I'm not sure that we entirely understand what that means. If the CCNRs prohibit parking in the driveway when you have a garage, do you have a legal right to park in your driveway? Not quite sure how that one would be enforced or operate in reality. It also prohibits a rule from interfering with an owner's right to operate a vehicle, except for a commercial vehicle, in accordance with the traffic laws. I see this as somewhat concerning because we have a lot of little communities who have private roadways who have reduced the speed limit, you know, to something like 9 3/4 to get people's attention and get them to slow down. And this may interfere with their ability to do that. HB 327 also says you can't use a rule to restrict who an owner hires as far as vendors or contractors based on the HOA's preferred vendor list, or because the professional vendor or contractor doesn't have a professional or occupational license. This is obviously a concern. We don't want an unlicensed electrician, if that's such a thing, to come and mess with electricity or things that are going to cause more widespread damage. So I believe we're trying to have a conversation with Representative Tusher about that. If you'll go to the next slide, please. HB 327 also adds political flags to the items that we can't restrict in a window or on the exterior of a home. But we'll still have the ability to restrict, you know, set reasonable time, manner, place restrictions. Still have the ability to put for sale signs in the window. There's some grammatical changes that aren't significant, but the issue comes up with flags and how big a flag can be. It should be interesting. I've seen some pretty crude flags lately that could be political, so I guess we might be testing to see what the legislature's appetite is for that. If you'll move to the next slide. This change is only for communities under the Community Association Act, and under HB 327, it would prohibit a rule from banning vegetable gardens on a homeowner's lot. A vegetable garden, it contains not just veggies, but herbs, fruits, plants that attract pollinators and flowers. While the outright bans wouldn't be allowed under 327, reasonable guidelines could be put in place, like height restrictions or prohibiting invasive or illegal plants, or some restrictions on fertilizer and water use, ensuring that things aren't, you know, highly chemical or similar issues. HB 327 doesn't really have a financial impact, which is usually a signal that we might have an opportunity to shut a bill down. But this bill is now waiting for a hearing before the House Political Subdivisions Committee, which is pretty strange because it only modifies the Condo Act and the Community Association Act. Typically, we would still see a bill like that go to the House Business and Labor Committee. And I'm unsure, and I don't know if anybody else on the LAC knows why this one got booted to the House Political Subdivisions Committee. So we'll have to stay tuned and see if Representative Tusher will consider some of our requested changes, like vegetable gardens. We would like to have those in an enclosed rear side yard, not in someone's front yard. We think that's not unreasonable. So remains to be seen. If you'll go to the next slide. Tusher has also introduced HB 337, and this is now on its second substitute. And it's particularly focused on property managers, and it would require licensing from the Real Estate Commission, who can make rules, set some exam standards, set some training standards. These, if you're already a licensed broker or an associate broker or a sales agent, you probably won't need a license. So there's probably an exemption requirement. And some people won't need a license. So if you are an owner managing your own property, or it's your immediate family member's property that you're managing, you won't need a license. If you are an assistant performing support tasks like maintenance or bookkeeping, you would not need a license. And regional managers or corporate officials that don't directly engage in real estate property management. So I don't know, Scott, I guess if you just sit in the office and you stop visiting communities and engaging with boards, you wouldn't need a license under HB 337. 337 would allow property managers to really take some agency over the properties that they're managing, filling out forms, signing contracts, lease agreements. They can solicit referrals and pay referral fees to unlicensed individuals for getting some property management business. They could advertise rental properties and act on behalf of the owners for financial transactions. However, property managers would need to associate with a financial institution that has a real estate trust account to keep that money protected. Tenant deposits, rent, other client funds, the HOA funds, just like we have a separate HOA account requirement now, those funds, if they're going to be managed by a property manager, would need to be in a trust account unless the property manager has a security bond that covers at least 30% of the amount of client funds that they are holding. There are some enforcement mechanisms. I think those are intended to be fleshed out more by the Real Estate Commission when it starts to develop rules and set some examination and education standards. This bill is expected to eventually increase some state revenues, so about $180,000 a year from property management license fees. You know, initially it'll cost about $100,000 to get this program up and going, the fiscal note indicates, but after that, it'll probably bring in, you know, $80,000-$90,000 a year to the state. It's anticipated that about 2,000 people in Utah would be required to get a property management license, and there'd be a $90 application fee, which is where that revenue is generated. There might be some additional costs for education and examination requirements, but we don't have those numbers yet. That would be up to the Real Estate Commission. HB 337 did receive a favorable recommendation just yesterday from the House Business and Labor and Commerce Committee. So it should be moving, I believe, to the House floor next. And that's it. Thanks. Do you have any questions? Oh, I missed that slide. Sorry. I already talked about it though.
Okay, great. We're to the home stretch. Let's start with HB 86 this is Walt Brooks out of Washington County. This is one that particularly impacts any managers or owners that live in a developer controlled community. So Representative Brooks has proposed a very aggressive bill that is opposed by the Property Rights Coalition and the Home Builders Association. They're actively opposing this, and he has not expressed any willingness to back down. So this will be an interesting fight because those are a couple of very strong lobbies and a very resolved and determined representative. And so it'll be interesting to see how this turns out. So the next slide will explain what he's trying to do. There's really two components. He wants to require developer turnover to occur earlier than it often does currently. And he wants increased penalties for records requests that go unfulfilled. So you can hit the next one. The specific proposal for a community of 300 lots or greater is that the declaration must specify a date for turnover rather than it being a formula that says until the last lot is sold or until 75%. Or if you don't have a date, the automatic trigger will be the earlier of when you hit 75% of lot sales, 7 years after ceasing to offer lots for sale, or when the developer voluntarily surrenders. So that's for communities that are 300 units or larger. The next slide describes the standard that he's proposing for a community of 300 lots or fewer. You don't get to establish a date in the declaration. Instead, it would just be the earlier of 60 days after 75% of the lots are sold, or 1 year after ceasing to offer lots for sale. So that's very different than a large master plan, which gives you 7. This would just be 1 year after lots sales stall out, or voluntary surrender. So this would be a very big change to what's currently in the Community Association Act, which defers to your governing documents. And many developers they retain the right for developer control all the way until the last lot is sold. I'm sure on this seminar today, there are people with all kinds of viewpoints. Some are probably rooting for Representative Brooks' bill to pass, and others are probably terrified about it. Let me show you on the next slide what has been proposed to replace this turnover section. Ryan, is the next slide available? Okay. Currently, under Utah's case law, there's a series of fiduciary duties, 7 limited fiduciary duties that a developer owes. And it's recognized by the Davenport case. The proposal by the Home Builders Association and the Property Rights Coalition is to delete this early turnover section and instead codify and adopt the 7 separate duties that are owed by a developer during the period of administrative control. So I personally really like that proposal. I think it better educates homeowners of the developer's duties. And I think it educates some developers that aren't even aware of the duties that they owe while they're in control of an HOA. Stay tuned. We'll see how this goes. There is a meeting next Tuesday at 4 p.m. with Representative Brooks to talk about this proposal to adjust his bill. So we just don't know where this one's going quite yet. Okay, looks like we had a couple questions that came up. Janai asked if this relates to sale or closing, and it is referring to when they're offered for sale. So the triggers go from when you're no longer offering for sale, or if it's the 75% standard, it goes from when they're closed and transferred to a new owner. Justin Kaling asked a great question. How does this take into consideration developers who slowly purchase and take on additional land? This is very problematic for those developers, and they should be actively engaged in seeking to either shut down this bill or seek an amendment that would allow them to bring on additional phases as they acquire land under a contract or however else they gain it. The other simple provision in Brooks' bill is to expand the penalty for failure to satisfy records requests from a $500 penalty to a $1,000 penalty. We've discussed this in the LAC, and we don't have a lot of opposition to that. Hopefully our boards and our managers are being diligent, and you'll see here in the next bill that if it passes, there will be an expanded period of time to respond to records requests, which will make that more reasonable as well. So the takeaways from this one, if you're a manager or if you're involved in a developer control community, try to look for ways to involve homeowners more. It's a feeling by homeowners when they don't feel like they have a voice or a seat at the table that causes them to go to their representatives to seek harsh legislation like this. So that's one of my takeaways. And the second one is be transparent with records. We've really narrowed the scope of records that are permissible. So all HOAs should have those readily available and be responsive to your owners in providing records so that we can hopefully resist adverse records requests and expansions of the records rights in statute moving forward. Okay. On to the next one. And this one is a doozy, guys. HB 17 is by Neil Walter in Washington County. Although it has some very challenging features, I do have to say that Neil Walter has been excellent to work with. He came to our Southern Utah event and listened to us, and he's been very willing to meet with us and continues to adjust and try to find the proper balance on this bill. So a big thank you to Neil Walter for his willingness to hear a new perspective and to try to strike the appropriate balance. I do think ultimately we will probably disagree on a few of these items, and we'll probably get to a great place of compromise on most of them. So let's start on the next slide with the HOA ombudsman proposal. What is an ombuds, also known as an ombudsman or ombudsperson? Different states will use different terms. I think the trend is to refer to them as ombuds. An ombuds is a neutral individual that helps to resolve conflict. And Utah already has an ombudsman's office, the property rights ombudsman, but they have no jurisdiction or authority to hear HOA disputes. Representative Walter's proposal is to create an ombudsman's office to entertain complaints that are lodged either by an HOA or against an HOA, related only to failure to comply with the law. So that's significant because prior ombudsman statutes that we've seen proposed over the last several years would allow an owner to bring forward a complaint related to any matter, whether it's contract interpretation, adherence to the CC&Rs, rule enforcement, anything. So his bill limits it to anything that an HOA or in theory a property owner is not doing, a lot owner is not doing to follow the law. It also requires that before a homeowner bring the claim and before there's jurisdiction at the ombuds office, that the owner satisfy all the requirements of the governing documents, including any advance notice requirements, alternative dispute requirements, hearing requirements. They must certify before the ombudsman's office has jurisdiction that they have met the requirements of that specific HOA. So if this passes, something you'll really want to consider is adopting an alternative dispute resolution process or a hearing process before it goes to the state agency. We do have some model language out of Virginia for HOAs to consider there if this does become a reality in Utah. The LAC does oppose the ombudsman portion of Neil Walter's bill. It does have a fairly high fiscal note. It's roughly $500,000. They propose to hire 2 full-time attorneys and to have a executive director over that office. And so we think that that's not a wise use of our tax dollars, because in the 6 other states that have adopted HOA ombudsman's programs, our CAI affiliates in those states have said it's been a disaster, that it has not been an effective way to resolve conflict. Instead, it becomes a forum for owners to lodge complaints. The feedback we've received from National CAI is that nearly all of the complaints are dismissed as unfounded, and that it ends up costing associations a lot of money to deal with groundless and frivolous complaints. It's not binding. The advisory opinion issued by the ombudsman's office is just that. It's an opinion giving advice. It would not be binding, and it would not be admissible in court, except if there's a finding that the HOA knowingly and intentionally violated the law, in which case an owner could bring a claim, and if that's proved in district court, they get a $250 per day penalty from the date the opinion was issued until the date the judgment was issued by the court. So litigation can take years to resolve, and that could be tens of thousands of dollars in penalties alone if an HOA chooses to stand their ground if they disagree with an ombudsman's opinion. We don't like that there's not appropriate mutuality. Although there's a penalty for HOAs, there is no penalty for a lot owner that fails to comply if an HOA chooses to pursue a complaint through the ombuds office against a lot owner. So for these reasons, we've urged him to reconsider the ombudsman's portion. We think the fiscal note could be a challenge for him. This is a very tight year fiscally for the state of Utah. So it could be that that aspect of it requires that that be removed from 217. We'll wait and see on that. Okay. The next component involves what is a new definition called an association transfer fee. So this bill has the potential to create a lot of confusion. We know that the terminology surrounding reinvestment fees and transfer fees already causes confusion in our industry. An association transfer fee is something entirely new. It is not a transfer fee as defined by the code, and it is not a reinvestment fee. So instead, and I believe the next slide shows the definition, an association transfer fee has a definition very similar to a reinvestment fee, but the intent is that it does not need to be adopted by an owner vote or to be included in the CC&Rs. Instead, it's intended to authorize a manager or an association to charge a fee separate and apart from the reinvestment fee for administrative cost related to the transfer of property. And it caps it at $100. So we are aware that these type of fees are being charged currently in the market. This would cap it at $100, and it would be an extra fee in addition to a reinvestment fee. So we welcome your feedback. Is the amount appropriate? We probably want to look at a definition here that avoids the confusion because it's so similar to the definition of a reinvestment fee that I fear owners and even managers and HOAs tasked with carrying this out will be scratching their head trying to figure out whether it's a permissible fee or whether it's prohibited and must be in the covenants. Okay, we're getting some feedback already. One suggestion is that we increase this to $250 as an appropriate amount. Another suggesting that $100 is insufficient. So that's good feedback. We'll take back to Walter and see if we can get that portion increased. A question by Bruce Cutler about records requests and how often they go unfulfilled. I would say it's actually fairly common that an HOA misses the deadline to respond or is incomplete in responding to records requests. So it is a challenge that we grapple with in our community, in our industry, where owners feel like they're not receiving full and transparent responses to records requests. Okay, another suggested $300 with an increase for CPI each year. So lots of people giving feedback that $100 is not enough. If you feel strongly about this, I urge you to email Neil Walter and express that, because he's heard a lot from us, but hearing from new voices makes a big difference as we're negotiating adjustments and revisions to these bills. Okay. Next, his bill addresses reinvestment fees in addition to this new concept of an association transfer fee. What he's proposing to do here is to say that an association may not impose or even set the amount of a reinvestment fee unless a majority of voting interests in the community approves that. So, as you've probably seen, many reinvestment fees are simply drafted to allow a fee up to what is permitted by law. For most communities, that's 0.5%. For a large master plan community, which is 500 units or 500 acres or more, there is no cap of 0.5%. And the board by resolution often sets that either at a flat fee or at a lower percentage. And that allows you to be adaptable to market conditions, to go up or down to facilitate sales in the community. What Walter is suggesting is that the boards would not be able to set the amount of the reinvestment fee without the approval of a majority of the community. This is a big concern for me, especially for large communities that are run very well. Because in my experience, when communities are run well, the percentage of participation decreases and you have a lot of apathy and it's hard to get owners engaged. And so the board, who's dealing with sensitive budget issues and is looking to set that amount appropriately and does the homework, would then need to go get a majority of the entire community. And in a large community, getting a majority together is very challenging. I met with Neil Walter yesterday afternoon. He was very sympathetic to that concern. And now it's on my plate to try to go draft a solution to that. One thing I wanted to throw out to our community and to get feedback, and we'll certainly discuss in the LAC, is perhaps we adopt a procedure where a majority of the owners can veto if the board does something that they feel is unreasonable. So instead of putting the onus on us to go get an affirmative vote, the owners have the ability, if they don't like it, they can gather through petition and veto it. We already have that concept with budget approvals, with reserve fund line items, and with rule adoption. And I think it would be appropriate in this case as well. Okay. Great feedback about the limits to reserve funding. If reinvestment fees are limited, absolutely something we're discussing with him, and we'll keep that in mind. Another question, how does this work with an already established reinvestment fee? This is always something that we grapple with. When we have a new statute that doesn't specifically address retroactivity, each association needs to evaluate whether their governing documents contain an internal retroactivity provision. And many of them that do, they have a provision that says we're subject to the act as the same may be amended. So our own community might have a retroactivity provision contained within our governing documents. And it's not always clear whether these provisions apply to everyone, regardless of when you're created, or only on a prospective basis. So that's one of the challenges we deal with in our industry. And I don't have a clear answer for you on that one quite yet. Okay. Next. The next topic addresses late fees and interest. Neil Walter has reportedly received many complaints from homeowners who have been subject to what they consider to be abusive tactics by the HOA in terms of very excessive late fees and interest rates that are applied to delinquent assessments. His current proposal is to limit late fees to 5% of the assessment amount, or $50, whichever is less, with interest of 1.5% per month, 18% annually on the assessment and the penalty. He's open to negotiation on this. So again, I welcome feedback if you think there's an industry standard, but he's not willing to delete this section and allow it to be governed only by a rule as adopted by the association. I will flag that this is in subpart 5 of the rulemaking section, and it is one of the subsections that allows the governing documents in the CC&Rs to differ from the rules. So as currently drafted, this would only limit a late fee or a penalty, an interest penalty that's imposed by a rule, and would not override a different provision in the CC&Rs. So I'm raising that to this group. I don't really want to put a highlighter on that as we work with our lawmakers on that, because this does allow for a little more autonomy and contract freedom for an HOA as long as it's contained in the CC&Rs. Great feedback. Can we avoid specific dollar amounts and go to percentages, because dollar amounts become outdated so quickly? Great feedback, and it's often something that we raise. The response we often get is, we'll come back and change it if it's too low. And we know that that's expensive and burdensome, and so we're with you on that. Percentages are always better in statute than fixed dollar amounts. Okay, great feedback also on the limitations of reinvestment fees. It sounds like this group is very aligned that we need that tool and we need the flexibility to help fund our HOAs. I believe the last section of his bill relates to expanding the records that are available to an owner who requests them. And I don't really have any concerns about F, G, and H, which are displayed on the screen. Minutes from the prior 3 years, profit and loss, and balance sheet, although we need to ensure that we only have to provide them to the extent they're available. Some of the feedback we've received from managers is often when they take over, they don't have a great set of records to provide, and they're just going off, they're creating a new body of records. And I think that's valid. The one that really concerns me is this last one, a copy of each service contract to which the association is currently a party. I could really see this being abused by an owner or even competitors in the industry who are trying to find out the rates of a competitor landscaper or snow removal company, or even a property manager, a community manager of an HOA. it seems a little intrusive to allow any owner as a matter of right without any stated proper purpose to obtain that copy of all active service contracts. And so I raised that concern in our meeting to Walter yesterday, and he was actually very sympathetic to that and said he wanted to think about it, but I anticipate that line item will be deleted in a substitute bill in the incoming days. I did want to highlight, and I didn't have this up here, I don't think, on my slide. It also expands the time period to respond from 5 days to 14 days, which I think is very welcome. Sometimes when these requests come in, especially if it's on a spring break or you're out of town, a 5-day turnaround can really catch you by surprise. 2 weeks provides a better opportunity to respond to an owner that's requesting these records. Okay, do we have any questions that I've missed along the way, fellow panelists? Have you by chance been monitoring any of those?
I think you've got most of them. Most of the comments, the questions are, like you mentioned, are regarding the reinvestment fee and being able to use them, the concern being able to, for budgetary considerations. The LAC is concerned about that. Other than that, I think there is a big support for your proposal of putting the onus on the owners to overturn the reinvestment fee amount. Put the
Right.
ball in the court if they want to mobilize to overturn, then that would be welcomed. And then
Yeah, just making sure that we give them contact information to refute some of these bills that we're against.
yes.
Okay, so why don't we do this? We are over time, so I'm going to make a quick plug. There's a lot of work that goes into this legislative action committee. All of us that are on here today that have presented are volunteers. So we appreciate the volunteers, and many, I think all of us have contributed money as well. So we're volunteering time and we're contributing money to help pay for our lobbyist, who is very effective and very helpful in setting up these meetings that allow us to push back and revise and even to advance our own causes. I would ask you, if you're on this call, would you please consider talking to your communities, whether you're on a board or your manager, and inviting them to pledge $1 a door or more per year towards the Legislative Action Committee that can be used to help pay for our lobbyists, which is our main expense, and it makes all the difference at having a seat at the table. For a big community, this might only be a few $100s a year, but it makes a big impact to us to have contributions from HOAs and the communities that you manage. We will send out these slides, and we will also send out contact information for the various representatives that are sponsoring these bills. We're not to the point yet where we're requesting a call to action, but will you please watch your inbox as well? If we get to a crisis point where our negotiations have broke down, sometimes we do a call to action and we ask you to reach out to your personal representative to encourage them to vote no on some of this adverse legislation. So again, I know we're over time. Thank you so much for the panelists for preparing and presenting, and thank you for the attendees for being here, for your interest and your feedback. We will monitor these texts, the chats, and the questions that came through, and please monitor your email for a call to action, and consider please donating to the LAC. But thank you guys so much.
Thanks, everyone.
You